Hey, this is Mike McKinley with Elder Care Law of Kentucky, and I'm going to do a quick video. I had a client ask me to explain the difference between the different types of irrevocable trusts. So this video is to clarify and to give some additional information to try and help people distinguish between the different types of irrevocable trusts. One of the issues I find people Google or do searches on irrevocable trust, and they read something and they say, "Well, this doesn't sound like what anything I would want." The problem is it's like calling something a hammer. There's a million different types of hammers that are used for a million different things. If I sell someone a regular 24-ounce hammer for hammering in nails, and they do a Google search and they find a sledgehammer, they're not going to think a sledgehammer is very appropriate for hammering in nails. Of course, it wouldn't be. The problem is they're both called a hammer, but they're very different things. So, for the purposes of elder law and for asset protection planning as it pertains to Medicaid, as it pertains to the nursing home, uh, the irrevocable trust that we use is very different. First off, it's a first party irrevocable trust, meaning I'm the grantor, I'm the settler, I'm creating a trust for myself with my money. Okay, that means it's a first party trust. Um, in order for me to get asset protection on a first party trust, there's lots of rules and restrictions that have to be in the trust for it to give me the protection. Typically, I cannot be the trustee. Uh, I cannot, because it's my money that I'm putting in the trust, I can't retain control. Obviously, I can't retain the title. Title is now in the name of the trust, but title and control cannot be maintained in order for me to protect my assets and for them to be legitimately uh, out of my control and to be accountable resource for Medicaid purposes. So a lot of my clients will read the trust and see that it says that my my clients cannot be beneficiaries of the trust, which is true. They cannot be. We have to name children or friends or someone else has to be both the lifetime beneficiary and the death beneficiary. Obviously, you can't be a death beneficiary if you're dead. Uh, but even the lifetime beneficiary, we don't want to allow our clients to be legally entitled to receive money out of the trust because the Medicaid agency reads that and says, oh, well, that's accountable resource. If you're legally entitled to pull money out of that trust, it becomes accountable resource. Now, because we mostly are not worried about estate taxes when I'm dealing with my clients because the estate tax exemption is so high. As we sit here today, I think it's in excess of $13 million. We don't worry about whether or not the assets will be included in your gross estate when you die. We actually want them to be included in your gross estate so that your children will still receive, or your heirs will still receive, a step up in tax basis on the property. So if you have stock, real estate, any other kind of asset that has appreciated over time and is worth more today than when you first bought it, we want your children to receive that money with a step up in basis so that if they sell it soon after you pass away, they don't have to pay capital gains tax on the difference between what you paid for it and what it's worth today. Okay. That can be a lot of money, particularly with real estate. A lot of people bought houses, 30, 40 years ago, and the houses might be 10x what they paid for them now. So you don't want your children right after you die to sell something and have to pay 15% capital gains tax on that property when they sell it. So, we want the when we do asset protection planning, we want your assets to be a part of your gross estate for IRS purposes. That has nothing to do with the protection that these trusts afford you from the nursing home and from estate recovery after you die. The IRS and the Medicaid nursing home agencies are completely different. They have nothing to do with what we're with each other, and they have different rules of how they review trusts. So the technical term for This trust that I create typically for my clients is a intentionally defective grantor trust. Um, we call them idiots. So they're intentionally defective for IRS purposes, meaning just because we put property in the trust does not mean we have removed that property from the gross estate calculation that gets made when we die. We want that to be included in our gross estate so that our kids can get a step up in basis. Um, if you're fortunate enough to have an estate tax problem where maybe you've got $20 million dollars and every dollar above 13.5 million will be taxed at 40 or 50%, then we're going to create a different type of trust. This trust is going to be a true irrevocable trust that removes that property from the gross estate calculation when you die. So the kids may still have to worry about capital gains taxes because you've removed the property. So whatever your tax basis is, the trust when you give that property to the trust will keep that tax basis. So your children may have to worry about paying a 15 or 20% capital gain tax on that property, but they're avoiding the 40% um, estate tax that they would otherwise have to pay to the federal government. It's a different deal. If you don't have more than $13.5 million, you don't have to worry about it right now until the law changes, and then we readdress things at that point. Um, so that's the difference between the two types of irrevocable trusts as it pertains to asset protection planning from the nursing home and uh, estate tax planning from the IRS. They're different deals, and it's a different form of planning. And frankly, if you have an estate tax issue, you're probably not worried about spending two, three, or 400,000 in a nursing home before you die. The very small percentage of the population are in that camp. Most of my clients, the number one threat to their estate is the nursing home, not the IRS. Now, let's talk about the difference between first party and third party. Um, if I'm going to receive any type of inheritance from my parents, um, in excess of a couple 100,000, say, I want to receive that money in an irrevocable trust that my parents create for me. Now, because my parents are creating the trust for my benefit immediately, they're putting their money in, but it's for me. I can be the trustee of the trust and have access. So, unlike the first trust we just spoke about, where if you're creating it for yourself, you cannot be the trustee, but because it's my parents creating it for me, I can be trustee. So I can be trustee for a trust that holds property that did not belong to me in the first place. So if it's somebody else's money coming into the trust, I can control it. So now I can have control and access. Um, where with the other type of trust, you can't have control or access to it. So, or you can still have access to it if your trustee takes it out, gives it to the lifetime beneficiary, then which is usually themselves, and then gives it right back to you. But there's no legal obligation for them to do that. They're just going to do it because they understand that it's your money, and you can always fire them as trustee if they don't do it, um, etc. But if it's money that I'm receiving from my parents, I can be the trustee and I can have access. So I can be beneficiary and trustee. If I need to take money out, it's going to be for my health, education, maintenance, and support, which is a very broad standard that can cover a whole lot of property in a year for me to take money out. If I'm smart, I'll leave as much money in that trust as possible unless I actually need it and want to spend it. Otherwise, it's going to stay in that trust protected in case I get sued, in case I become disabled, in case I get a divorce, or in case I die. If I die, my money's in this trust. It can now go to my daughter outside of my estate and be protected for her. It's not going to my wife and her new husband. Um, and I can name my daughter as a benefit, or I can name my wife as a beneficiary as well, where she can have access to it. But it won't be part of her estate either. So if she remarries and then passes away soon after, it didn't just go to her new husband or her new husband's family. So there's lots of benefits with receiving money in a trust. Now, ordinarily, we don't want to. We typically only do it if there's a substantial amount of money that they're going to receive, and that's a very generic term. What you define what substantial is. To me, anything over a couple hundred thousand is substantial. But if I'm I'm a doctor, or I'm some kind of inventor, and I've already got millions of dollars, a couple hundred thousand really isn't that much money. So maybe I just have mom give me that money outright. It's not worth setting up a trust for it. But for a guy like me, a few hundred thousand is a lot of money, so I would want to receive it and have it be protected. Um, so it's a very subjective decision as far as when do you leave money in trust to a child versus not leaving money in trust. The amount is a big factor, but also the child themselves. So if I'm an alcoholic, never leave me money. You always want to, even if it's 50,000, you leave it in trust. Um, if I'm in the middle of a bankruptcy, okay, and you die and you've just left me an inheritance, now that money is available to my creditors. So you've just left that money to whoever's suing me potentially. Um, the same thing. So we talk about the 4 Ds that we protect our children from. Death, meaning they die soon after they inherit the money. Divorce, which is obvious. Disability and debt. Okay, so debt would be creditors. I'm upside down. I have a business that goes under, whatever the case may be. Money you leave me in trust is protected. Okay. So that's just a quick and dirty overview of the different types of trust and the difference between the first party, which is I put my money in it, which means that I cannot be the trustee of it and have it be protected at the same time. Or it's money that I create, or it's a trust that I create for my daughter, and I'm putting my money in it for her sake. She can be the trustee and control it. Okay. So if you have any other questions, give me a call, Mike McKinley, Elder Care Law of Kentucky. My phone number is 859-298-2150, and reach out to me if you have any questions. Thanks.